That is correct, Your Honor.
At this point, based on my earlier ruling,
Officer McAvoy, BWC number 1.
You got ID? Do you have ID on you? Do you have ID? All right. What's your name? Stop. What's your name? You got...
And now I'm going to show you the clip one more time. And at the end of the clip, I'm going to stop it.
You got ID? Do you have ID on you? Do you have ID? All right. What's your name? Stop.
Back a couple seconds.
What's your name? What's your name?
Title, file name, Officer McAvoy, BWC number 2.
You could have just pulled that out. I do. All right, fine.
You have my ID.
Put your hand behind your back.
You have my ID.
Put your hand
I
behind
did
your
not
back.
do anything wrong to you.
Put your hand behind your back.
You have my ID. You have my ID. I ain't
Behind your back.
My ID.
Behind your back.
You have my ID.
Behind your
You
back.
have my ID.
What are you
You
reaching
have
for?
my ID. You have my
Put your
ID.
hands behind your back.
You have my ID.
Hands
You
behind your
have
back.
my ID.
Put your hands behind
You
your back.
have
Under arrest.
my ID.
You're under
You
arrest.
have my ID.
Put your hands behind
You
your back.
have my
Stop.
ID.
Stop resisting.
You
Stop
have my
resisting.
ID. You have my ID. My ID is on the ground. You
Stop
have my
resisting.
ID. You
Put
have
your
my
hands behind
ID.
your back.
Can I take off my book bag, please?
Put your hands
You
behind your
have
back.
my ID. That's what I'm saying. It's on the ground.
Get back.
You have my ID. Please.
Stop resisting. Put
You
your hands behind your
have
back.
my
Work
ID.
number one.
You have my ID. You have my ID. You
Put it
have
behind your
my
back.
ID. My name is Christopher Pate.
right.
You have my ID.
Behind your back.
You have my ID.
You're gonna get tagged. Get tagged.
You have my ID.
You're behind your back.
Please.
Behind your back. Stop resisting. Stop resisting.
Please.
Stop. Keep it behind your back. Resisting.
You have my ID. Please. You have my ID.
Freaking, yeah. You crossed the road and you were uncooperative.
Yeah, and you look like a guy who worked for you, won't show us your ID.
Okay, let's make it 17.
Roll.
Make a big thing out of nothing, dude. Yeah. 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 Touch some things.
Can I take off my book bag?
We got your book bag.
You make this worse than this.
Please. You have my ID.
Fucking kidding me? Think this is what I want to do today?
I know.
You want to play stupid games? It's unreal.
Should we stop it?
Do you think that at this point, all these,
Okay, go ahead.
It's unreal.
Reach your leg in, step up.
Detail someone. You can throw cards down. We're outside. We can off.
You have my ID. Please. You have my
What's your
ID.
problem? We have established. We have your ID.
What are you reaching for that you don't put your hands
What is in your waist? What are you reaching
I
for?
have a lighter to light up my cigarette.
Okay,
That's all.
why are you being so uncooperative? You would just stop. This would be nothing. This would all be over. But instead, you want to act like a clown. So you're going to jail for the pettiest of offenses.
Please, you have my
Not
ID.
using crosswalk.
And not obeying officer's command.
I didn't do anything wrong, sir.
Yeah, someone get you a camera and a neighborhood truck. I'm sure these people, they all got videos. I'm sure they're going to be very
I'm
cooperative.
not even anyone that you're looking for.
Yeah.
I was going to
And that's why I was asking you for your ID, which at first you didn't give to me.
But then I'll
But then when you want to be a smart ass, then we're going to ding you for crossing the road illegally.
I apologize.
That's it. He looks like James Barrett. I step out with him. He's like, I was like, you got ID? And he's like, you have no reason to be stopping me. I go to grab him. Eventually, he pulls out his ID. It's not him. We're like, okay, you're going to play that game? You're going to go for jaywalking. So we found him over here, asking for his ID again. He's saying, you have no reason to stop me. Go hands on. All he keeps yelling is, you have my ID, you have my ID. Keeps reaching in front really hard. So he's just being a freaking asshole the whole time. Yeah, I know. Damn it. Fucking garbage. For nothing.
Judge,
Okay, sure. At this point, we're going to stop the video at completion of viewing the objected to portion of the DVD. Deputy, could you assist her? I don't think that has, or when that belongs to a news station. A news station. Do we have anything for her? Microphone? All right, use you're trying to call the kids from the backyard. Okay.
The court, we will go back on the record. I will read this to the people in the court. All right, this court is in
Okay,
session now.
I'm gonna stop you. Can you have enough cord to get by this mic? Here we go. There you go. You got a small bag there.
back on the record. I will read this to the people in the court. All right, this court is in session now with the prosecutor, defense counsel, and the defendant here. My law clerk, deputy, and myself. There was a point during the playback that Mr. Zimmerman said, "Your Honor, I object," and I held up my hand. Nothing was said at that point. I then, at 3 or perhaps 4 points, asked the prosecutor to identify where in the tape we were. So that is what has transpired verbally since we were in court. I've now had a chance to view the tape. We'll go out on the record and I'll hear any objections that anyone has. Between now and when we go back on the record, I want you to consider whether, because probably there is a transcript that was, for demonstrative purposes only, I have not viewed it. People, counsel was given a copy. You presumptively have a copy that you received this morning just before trial. There may or may not be some comments made on this portion of the video that are arguably relevant as they tend to prove or disprove a fact and issues are material. There may be large portions of that, any material may be outweighed by the prejudice to the fact finder, were considered by a fact finder. All of what I'm doing now, I'm doing wearing my judge hat, not the fact finder hat. We're in recess. We'll reconvene in the courtroom.
Thank you. So, ladies and gentlemen, that is what transpired in the jury room. It's the only portion of the trial that you weren't sitting here to hear, but I wanted you to hear what it was because I had told you we wouldn't talk about anything, but that there came a point where that did not occur. And so I needed to place something on the record, and I needed to do things while things were fresh in my mind. But now we're back on the record with a full courtroom. And having now viewed what's objected to as a judge, I'll hear your arguments as to why any or all of it is not admissible since you made the objection, Mr. Zimmerman. Then I'll hear the people's response, then I'll make a ruling.
Thank you, Judge. All these statements are obviously hearsay. I don't see there to be any exceptions by way of admissions or statements against penal interest. Any statements that might be attributable to Mr. Sippel really have they're vague. It would force the fact finder to speculate as to where they fit in and to what. In addition, I'm not sure there's large portions here where of this tape where Officer Sippel's not there. So any statement that may have been made just kind of out there as far as to go to anyone's state of mind, he's not even present, and you see that in the video. There's other very, in my opinion, statements attributed to the other individual in the tape that I would submit to the courts more prejudicial than probative. In fact, it has no probative value to the issue at hand. So I'm asking the court to preclude everything after the res gesti or after the alleged assault, and that's where the officers then separately go around the point.
Just so that you know, what is in evidence and what I will allow in evidence up until this point is the point at which you objected, or pretty close to it, when there was an officer just, I believe to be Officer McAvoy, just turning the corner, just at the corner and turning, walking back on the sidewalk. Up until that point, all of that's already in and will stay in evidence. What we're talking about is from the point at which he turns the corner and anything that transpires after that. And based on my making that clearer than perhaps I did earlier. Anything more you want to say?
No, thank you.
Ms. Parker?
Your Honor, the people would submit that, number one, that the entirety of the video goes to complete the narrative of the events, and that there's actually numerous lines of dialogue that occur throughout the portions of the video that we watched in camera that are relevant to the ultimate issue at hand, are relevant to the reasons for the arrest of Christopher Pate, and are relevant to the material issue of this case. And that, in fact, the other images on that video are exceptions to the hearsay rule, and that they are excited utterances, and go to show the state of mind of the victim as well as the other people that are in that video. And that I do disagree with defense counsel that some of the statements contained are declarations against criminal interest. And due to those reasons, we would ask that all the portions of the video be accepted into evidence.
The basis for excited utterance, to raise that as an exception to the hearsay rule, a lot of what is on that tape is hearsay. It would be introduced for the truth of the matter asserted in the statement, or if it's not hearsay, then I presume somebody would be asking it to be introduced as a verbal act or an act of independent legal significance, not for the truth of the matter, but because it completes the narrative or it explains what somebody did, the classic reasons why you would allow a statement not for the truth of the matter asserted in the statement. And the reason that I stopped and asked, where are we on this tape, on at least 3, if not 4 occasions, is because in listening to it, there, as a judge, became a question in my mind as to whether or not this did tend to prove or disprove a fact in issue. As you raise the excited utterance, there at least becomes a point where, as a judge, viewing that as an objection, I have questions as to whether or not the individual whose voice can be heard may be saying things knowing that what's transpiring is on tape. There is, in the court's view, a marked change in the tone, tenor, and timbre of that person's voice. What is said might lend one to believe that that is not a statement made in the heat or excitement of the moment, but rather a statement made for another purpose. So even if I were to accept that some of the statement made were an excited utterance, there becomes a point where clearly I would rule against you on that theory, that it is not an excited utterance, but it is after some reflection as to the situation the person may find themselves in, and does not fall within the parameters of an excited utterance. While I believe that there are portions of this, larger portions than perhaps you would find, or less of the breadth that the district attorney would want to be admitted into evidence, I find them to be material, but the issue is, and relevant, but the issue is whether or not the prejudicial value outweighs the probative value. I anticipate, though I don't know, but I anticipate that perhaps the individual who may have been speaking, if the fact finder were to find that, may be a witness in this proceeding. And that witness can certainly testify about any one of a number of things, including any post-incident feelings that he may or may not have had. I find that on balance, the prejudicial effect of playing that for a fact finder outweighs any probative value. I find that only portions of it would qualify as an excited utterance, but the fact that it may be legally admissible does not answer the question as to whether a fact finder should hear and see it. And I find that the prejudicial value outweighs the probative value of 98% of what was viewed by the court with counsel in the jury room in order to make this ruling as a judge. I did not view this as a fact finder wearing my fact finder hat, but only wearing my judge hat. There are, however, portions at or near 5851, just so that you have some reference, that I don't know who that is, but there may be things that would be admissible there, or at least a portion of that. There may be something that does qualify as an admission, or at least a statement that relates to the allegation that was returned as a prosecutor's information by the grand jury at approximately 1757 or 1702. The reason for my comment earlier to both of you that was read in open court with regard to the transcript is that just immediately prior to trial, the prosecutor presented at sidebar what purported to be a transcript of the entire videotape that had been prepared by someone. I don't know that it is a certified transcript. I don't know who prepared it. But I said, I'm not going to view that. I will view the videotape and listen to whatever is on the videotape and is admitted into evidence. But if I find, my recollection is what I said at the time, if I find that I can't hear something and I need something explained to me, then I certainly may ask for some clarification, or I may take advantage of what you have prepared for demonstrative purposes only. As anybody who's been in this courtroom this morning may have noticed, I didn't do that when there were things that I didn't understand or didn't understand who was talking. Instead, with a witness on the stand, I went through the videotape or portions of the videotape again so that I could determine for myself who it was that was speaking and what, if anything, was being said that I might have thought was inaudible. So I have not yet, and I don't, frankly, unless there's an offer made by somebody, and I would allow it, an offer made as to either these particular portions that I pointed out, the rough areas where I have some concerns as to whether or not the materiality and the relevancy of the statements made outweigh any prejudicial value, and I would allow them in upon proper identification. There is at least one statement in the area of 1757 that within context someone could infer who made that statement, in which case it would fall under a number of exceptions to the hearsay rule. I'm not going to decide it now. I said we're going to go to 1 o'clock. We've got a witness on the stand. We're going to do that. I'll determine that issue at a later point. But that's where we are with the objection. So in large part, I sustain your objection. Mr. Zimmerman, there are some portions that I may not sustain, that there may be alternatives to it being played if there's a stipulation by the parties. If there is not a stipulation by the parties, then I am going to ask you, Ms. Clark, to use whomever has taken over in your office for to carve out a DVD between now and tomorrow over in those rough areas that I've just mentioned. So if I determine, and there is no stipulation that the parties would enter into as to statements in and around that area, then I will rule as to whether the DVD itself in those specific areas comes in. Because as I said, I have at least an appreciation for a reasonable view of the evidence that any prejudicial effect would be overweighed by the probative value of those particular portions. But in large measure, I sustain the objection and you have an exception to that, Ms. Clark. We put the witness back on the stand, please. Is this something we have seen previously?
It is not.
Is this reportedly at the hospital?
No, Your Honor.
Do you have your ID? Do you have your ID, sir? Do you have your ID, sir? Sir, I'm talking to you. Do you have your ID?
I just showed you.
I need to
what
see it.
have in my hand. Look, you don't need to see shit.
Yes, I do. Put your hands behind your
You
back.
have my ID.
Put your hands behind your back.
You have my ID.
Put your hands behind your back.
I didn't do anything wrong to you. You
Put your
have
hands
my
behind your back.
You have my ID. You have my ID.
Now, we're going to do it this way. Put your hands behind your back. Do it now.
You have my ID.
Behind your back. He's reading something.
You have my ID. You have my
Put your hands behind your back.
You have my ID.
Put your hands behind your back. Put your hands behind your back. Under arrest. You're under arrest. Put your hands behind your back. Stop resisting. Stop resisting.
You have my ID.
Details
My ID is on the ground.
Stop resisting.
You have
Hands behind your back.
Can I take you for good day, please?
Put your hands behind your back.
My ID. That's what I'm saying. It's on the ground.
Get back.
You have
Get
my
back.
ID.
Stop resisting. Put
You
your hands behind
have
your
my
back.
ID. You have my ID. You have my ID. You have
behind your back.
my name is Christopher Pate. You have my ID.
Put your hands behind your back. You're going to get tased. You're going to get tased.
You have my ID.
You're going to get tased. Stop resisting. Behind your back. Stop resisting. Stop resisting.
Please.
Stop. Keep him behind your back. Stop resisting.
You have my ID. Please. You have my ID. I didn't do anything wrong.
You crossed the road and you were uncooperative.
Yeah, and you look like a guy we're looking for. You won't show your ID.
Okay, let's make it 78.
Okay, stop. Thank you.
Stop. What's your name?
Okay? All right, now, camera's down, video off. Now you can ask all the questions you want about it. We good to go? Okay, thank you. Right now, we're in recess. I'm not going anywhere. You're not going anywhere if you want to see what's going on, but because we're in recess, you can talk to the person next to you if you want to talk to the person next to you. My reputation is such that you wouldn't have felt comfortable doing that if I didn't tell you that we're in recess. Would that be correct, Mr. Nolan?
It would, Judge.
Thank you. All right, ladies and gentlemen, we're going to go back in session. At this point, I'd ask you to wrap up the conversations that you're having, if you would, please. First, Mr. Zimmerman and Iguadir.
If I may,
Yes, go ahead.
Officer McAvoy,